We will be looking at what the governors are asking for from two lawyers who will be helping us analyze what this is all about, whether or not the voice vote that was used by the National Assembly members to actually pass that vote for the president, sustaining the president's action in Rivers State, was actually something they should have done, or whether there are better options of voting they would have used. We'll be asking a whole lot of questions regarding the Rivers State issue. A lawyer, Abdul Aminu Mahmood, who is also a poet and former president, National Association of Nigerian Students, NANT, is here with us in the studio. Thank you so much and welcome.
Good to have you.
All right, another lawyer.
Yes, we do have another lawyer who's joining us via telephone, and of course we do know that Gagai Fodo is also a poet, lawyer and an APC member. He's joining us via telephone to have this conversation. It's good to have you. Good morning.
Morning, Mahmoud. How are you, my old friend?
All right.
Ogaga, I'm well. Good morning.
Interesting. We are having two lawyers and two poets. What a coincidence.
And two combatants from the National Association of Nigerian Students of the 1980s and 90s.
Really? What a selection. Anyway, but the difference here now is that you're not a card-carrying member of any party, or are you?
No, I'm not.
Okay, so you're speaking from a neutral point of view.
Absolutely.
Okay, let's get into it. Really, the president has declared state of emergency. In fact, even the administrator is taking actions already to see how the state can be stabilized and all that. Now, the PDP governors, 7 of them, say they are taking the president to court and they are seeking a reversal to this, or even asking the court to interpret whether the president has got the powers to even suspend the elected governor in the first place. First of all, how would you react to the decision of these PDP governors?
This is my first time of speaking to the steps taken by the PDP governors, 7 PDP governors. I think out of 12. It's understandable that Rivers State is not among the states that have gone to the Supreme Court for very obvious reasons. The sole administrator has sacked political appointees, which includes the Attorney General and Commissioner for Justice. So obviously, Rivers State wasn't able to join the plate in the Supreme Court. I welcome the steps taken by the seven PDP states. If for anything, it will help to deepen our constitutional jurisprudence, and it will also help to highlight, some of the limits and delimits of the powers of the president under our constitution, more particularly as they relate to section 305, which has become the contentious section of our constitution. If you ask me my view on this issue, the action of the president is contumacious of the constitution. I've scratched the hair on my head. I have not found any provision under Section 305 that grants the president power to sack or suspend governor, deputy governor, and democratic structures in Rivers State. Right. And we see the extension of of actions that are contumacious of the constitution with what the sole administrator is doing at the moment. Okay. He has sacked political appointees, commissioners, etc., etc. I don't know where he derives his powers from, but the statement I read from Rivers State yesterday said, pursuant to the powers conferred on him
by the president, who appointed him as the sole administrator.
As the sole administrator, as a lawyer and as a practitioner of the constitutional law. From on top of my head, I know that Section 148, subsection 1 of the Constitution, talks about assignment of responsibilities of the president to vice president and ministers. That section does not mention, a sole administrator. Absolutely. So I do not know where he claims to have derived his powers that he says that are conferred on the president. But more importantly, I think we must stress this fact. Something strange happened when, in the aftermath of the appointment of the sole administrator. He was sworn in by Mr. President. If you look at the 7th schedule of the Constitution, which deals with section 140, 142, 149, 180, 185, and I think 190, offices created under the Constitution. The Constitution says these occupants of this office must be sworn to oath. The Constitution did not mention sole administrator. So on what basis was he sworn in by Mr. President?
Okay, sorry, let me come to Barrister Ford, and I'm sure you can hear me, because one of the things he has said here is that it is an order for the governors to actually go to court and test out the constitutional jurisprudence of this matter. But then again, for a matter that needs at least 2/3 majority, do you think that voice votes was enough in this case? Was it constitutional?
Let me just start by saying everything is very untidy. And I think the problem we have is that the Constitution did not anticipate the very people who are a threat to the peace and good governance of Nigeria or any part of it will be the governors and the legislators themselves. As a matter of fact, the Constitution even expects the governor, when he has that kind of situation, emergency situation in his hands, to invite the president to declare a state of emergency. But what happens when the president and the legislators are the very ones who are fostering this impossible situation, making governance impossible? You realize, of course, that because of what has been going on, the federal allocations of the state have not been given to them until now, that we're given to the sole administrator. So I think the problem we have is that the Constitution did not anticipate that. There's no way the Constitution would think that a governor who will be the one, making his or her state ungovernable, or the legislators will be the ones who are supposed to enact laws for the good governance of their state, will be the ones who will make it impossible to even legislate. So here is the problem. I think generally, people agree, at least that a state of emergency is justifiable. I think the only thing that is bone of contention is whether he has the power to suspend the governor and the legislators, the House of Assembly. Now, yes, if you look at the Constitution, I wrote about this, I have an article that's out a few days ago. If you look at the Constitution, you won't find that power. That is true. But if you are the president and you are confronted with a situation like this, and the Constitution, as far as that point is concerned, is not going to be a guide to you, what are you supposed to do? If he does not suspend them, or let me put it this way, if the principal gladiators, the belligerents, are not, do not step aside, then they will be there, still carrying on with the deadlock, still carrying on with the logjam, still making it possible to govern for the state. And we already know that instead of sitting, that's the House of Assembly, to receive the appropriation bill as the Supreme Court directed, they find all kinds of reasons not to sit. What we're never interested in is to start impeachment proceedings. They're already giving notice of impeachment. So it means that if both parties, both camps were left intact, by now, or maybe a day or two after, Fubara would have been impeached. And if Fubara is impeached, one camp wins victory. In fact, just the way that camp was dancing, was delirious in joy, and saying that nothing can happen, heavens will not fall, they should impeach him if he has committed impeachable offenses. So he's impeached. And then one camp had total victory. If he's not impeached, then it will be seen as propping up a governor who actually demolished the House of Assembly, an arm of the government, demolished it. So it seems as if you're propping up a tyrant who will be the only one ruling by proclamations or his will, and anything he does cannot be challenged. So I think we have a problem. I'm glad the PDP governors are going to court. Hopefully, the Supreme Court will try to give some clarity here. But what happens when the Constitution is no help to a situation like this? The state cannot be governed. Something has to be done. And you cannot leave the people who are the very cause of the problem there to continue, because the problem will just keep on escalating. So okay. I do not argue by this that the president has the power under the Constitution. I too cannot find that power. But the question is, what is to be done? Because it's not enough to just say that. Something must be done. The problem has to be solved. What is to be done? And I think that's where the president took that step. salvage the situation. Will this argument prevail in court? We will see. Maybe that's not the argument they have. Maybe there's some secret weapon they have. The Attorney General has some secret weapon, some recondite section of the Constitution that they can rely on. We will see. But the bottom line is that something has to be done.
All right, Doctor.
And I don't think doing it will be to leave the belligerents in power so that they continue their fight to the finish.
All right, points well noted. Let's come back to you.
My friend and colleague made an important point there. The developments that we descend in rivers, rightly expressed by him, aren't captured by the Constitution in terms of how does the president respond to the development. What solutions?
Because probably the Constitution didn't envisage that the actors, really those who are elected, will be the ones embroiled in this whole field.
Let us go back to the provenance of the problem. The 27 legislators crossed from PDP to APC. The Constitution, under the relevant provisions of the Constitution, provides that the Speaker must give effect to cross-carpeting or defection. The Constitution did not contemplate that.
The Speaker will be one of them.
The Speaker will be one of them. One of them. Two, we have this problem on our hands. There was no contemplation that the President could go outside the ambit of the Constitution and exercise his powers. Ogaga made an important point there, and that is where I think that the government has not approached the problem correctly. If the President had come to tell the nation that on the basis of this, I'm strong by the Constitution.
Absolutely.
And we need to address the problems in Rivers State. I will be invoking the doctrine of necessity. I mean, would have been in a different field of law now. Can a president invoke the doctrine of necessity? Yes, on the basis that any action not contemplated, by the Constitution, taken by an executive occupant of the office, is presumed in law to be lawful. The Privy Council of England decided this principle in Matthew Bamuto and their book. And there have been lines of authorities around the doctrine of necessity. And we saw it too in 2010 in our country, when the legislature, for the first time, invoked the doctrine of necessity. But unfortunately, those in power, in the corridors of power today, are dancing around the issues. And like you asked, and also Ogaga raised, would the Supreme Court bring clarity to this issue or bring certainty to this issue? I am also worried, because decisions that have been made from the Supreme Court in recent times, do not show that the Apex Court is willing to bring clarity, certainty to our jurisprudence. Don't forget that when the Supreme Court had the opportunity in 2004 to address specifically the exercise or invocation of the powers or non-powers of the President under Section 3053 of the Constitution, the Supreme Court dodged it in Darius' case. So now, I'm not a prophet, I'm not a seer, but I think the 7 governors of PDP states will run into some brick wall at the Supreme Court if the defendants, raise the question of low-cost standard. And if you look at the very section in which they are invoking the powers of the court, Section 2321 of the Constitution, which deals with the exclusive original jurisdiction of the court. The provision talks about legal rights. The actions or action that was taken by Mr. President doesn't directly affect any legal right enjoyed by the 7 states, that have now gone to court.
Okay, so let's say this time around, something different would happen, because we've seen the state where this so-called lacuna or supposed lacuna in the Constitution has brought us, and the arguments they have brought back and forth since this emergency rule was declared. But let's go back to the Supreme Court now. At the end of the day, some people are asking, what happens if the Supreme Court endorses the action of the president at this time regarding, and that of the National Assembly, which also endorsed the president's declaration in Rivers State. What happens, really, from your own legal point of view?
Well, we
cannot preempt the court, you should say.
We cannot pick stones and throw at the justice of the Supreme Court. They are infallible, because they are also humans. But because it's the apex court, every party, connected to the dispute must have to respect the decision of the Supreme Court. But there's a danger for the Supreme Court to hold that a president who does not have powers within the ambit of the Constitution exercising, powers that he does not have poses some dangers for us, in future. We may have a president who will emerge who will not like Adaura, for example, because she's the governor of Imo State and she belongs to a different party. Creates some confusion, some crisis, some conflict in the state, and on the basis of that, hammer Adaura. That's the danger.
Let me come here, because I know I asked Bart before to this same question, but I wanted to hear your thoughts on it, and it's on the voice votes. And, the case of the 2/3 majority, which is required, by the parliament. You talked about constitutional jurisprudence, and when you look at this, one would have thought that the parliament, in knowing the constitution, would rely on this. But do you think that there is a danger in this precedent?
There is a danger. It is not a precedent. What the National Assembly did was follow a precedent set by the same National Assembly in 2004. When the issue of Dariye came up before the National Assembly. Rather than seek for a division, the National Assembly chose to exercise its powers with the voice vote. If you look at Section 3056, it talks about two-third majority. And if you flip back to Section 56 of the same Constitution, it talks about the mode of voting in the National Assembly. And I've consistently argued, publicly, privately, that important questions for determination, particularly constitutional questions, cannot be reduced to mere voice vote. One, you cannot achieve simple majority in some instances on the basis of voice vote. Two, you cannot achieve two-third majority on constitutional question on the basis of voice vote. So what the National Assembly ought to have done was to allow for a division, allow those who are oppose, the A and the nay, to cast their ballot on the important issue. But what the Speaker did, and we do not know what happened in the Senate because they decided to collapse into a cocoon, into a conclave, where they took their decision. But we saw what happened in the Senate. But unfortunately, and that is where I have a problem with the opposition. I expressed this here the last time I came. When the question was put to vote, at the House of Representatives, no voice, within the opposing camp of the parties in Parliament raised objection to it on the basis of Section 56, and I think on that 10 or thereabout of the standing orders of the House of Representatives. And don't forget too, Speaker Abbas rubbed it in the face of the opposition when he put the question to vote twice, and the acclamation was yes. There was no single voice that said no, and he did a third time. This time, rubbing salt on the consciences of the opposition members. When he asked them, do you have any other thing to say? There was no single voice. So on the basis of Section 56 and 3056 of the Constitution, the decision taken by the Senate of the National Assembly and House of Reps on the basis of voice vote, is unconstitutional. Right. And I'm happy the 7 PDP state governors are raising this particular issue as part of the argument in the Supreme Court.
Okay, so let's get to you now, Dr. Ifodu. Do you agree on this, the voice vote issue, and whether the National Assembly should have called for a division or even do their e-voting?
To be honest, I don't know why the National Assembly decided to go for it vote. But again, we could speculate. It could be that, they felt that they will not have a two-thirds majority. That's one speculation. But if the voice vote has to go to be unanimous, then again, it means there was no dissenting voice. Now, can we use the lack of a name to replace the head count of each vote? That's another question the Supreme Court is going to have to answer. If the Constitution says two-thirds majority, can a unanimous aye vote, voice votes, stand in for attaining the threshold of two-thirds majority without a count, head count of the actual votes? Again, it's a question for the Supreme Court. But what I know is that we have a messy situation. I tend to think that most of the problems we have are due to the fact that we're trying to practice democracy without Democrats, without patriots. If you are a Democrat and you are a patriot, you love our fatherland, love our native land, you want to do the things that would ground your state, make the people not enjoy the benefits of government for months. So who benefits? I asked this question the last time I was here. You remember that? Every governor, every legislator, every public official, every politician should ask him or herself, by my stance, by this action, who benefits? Me, individually, or the people, the common good?
Thank you.
And if the common good is not going to be served, they should have the courage to show themselves as patriots for once. Because look at what's happening. It's because they're trying to get the stuff in progress. Say, go back, represent
Indeed.
the appropriation bill to the House. Even when the Supreme Court has generously, said to reinstate them, even though they left their party.
I think this is. Sorry to interject. Sorry to interject. I think this would be a good place for us to, have this conversation to a pause. I know there is an ongoing issue, and we'll definitely be revisiting to see what the updates are, because I do know that they have said they're going to court. Next would be, will the Supreme Court also, like he said, look at this through all eyes of the law. But I want to thank you for your time this morning. And we've been speaking to two lawyers, and to Aminu Mahmood, lawyer poet, and former president, National Association of Nigerian Students, NANS, Okagai for the lawyer poet, and an APC